Article 200 of the Indian Constitution plays a crucial role in the legislative process, granting the governor a unique power to influence the fate of the bills passed by the state legislature. It defines the governor's options upon receiving a bill, paving the way for its enactment or potential roadblocks. Let's look into the specifics of this crucial Article 200 and understand its implications for India's federal governance. The three options of the governor. First one is assent. This is the green light. When the governor agrees with the bill and deems it constitutionally sound, they grant their assent, paving the way for its implementation as a law. Second option is withholding assent. If the governor has reservations about the bill's constitutionality, legality, or potential harm to public interest, they can withhold their assent. This effectively stalls the bill, preventing it from becoming law. However, the governor must communicate their reasons for withholding assent to the legislature, which can then choose to reconsider the bill and potentially amend it to gain the governor's approval. Third one is reserved for President's consideration. For certain sensitive bills, the governor holds the power to reserve them for the President's consideration. This typically applies to bills that the governor believes may significantly weaken the High Court's position or affect national security. Upon receiving the bill, the President can either assent, withhold assent, or dissolve the state legislature in extreme cases. There are some exceptions and nuances. Money bills. These bills deal with financial matters like taxation and spending. The governor's powers to withhold assent is restricted for money bills. They can only return the bill for reconsideration but are ultimately bound to grant assent if the legislature reaffirms it without amendments. Timeframe. While Article 200 does not explicitly define a timeframe for governor's decision, the Supreme Court has emphasized the need for timely action and discouraged indefinite delays. Debates and controversies. The governor's powers under the Article 200 have sparked ongoing debates and controversies. Some argue that it grants governors excessive power, potentially allowing them to act as political pawns for the central government and impede the will of the elected state legislature. Others defend the governor's role as a safeguard against unconstitutional or harmful legislation. Let's see the recent developments and controversies. The current scenario around Article 200 is marked by both noteworthy developments and ongoing controversy, showcasing its continued relevance and complexities in India's political landscape. Let's see some key aspects. Developments. Increased judicial scrutiny. Recent years have seen the Supreme Court actively intervene in cases where governors exercised their powers under Article 200. Notably, the court laid down guidelines in 2020 emphasizing timely decision-making and discouraging the governor from becoming a rubber stamp for the central government. Evolving interpretation of public interest. The courts have been grappling with defining public interest in the context of Article 200. This has been particularly relevant in cases involving bills related to social issues like environmental protection or minority rights. Next one is growing focus on transparency. Concerns around potential misuse of Article 200 for political ends have led to calls for greater transparency in the governor's decision-making process. Some states have begun exploring mechanisms for making the reasons for withholding assent or reserving bills more readily available to the public. Let's see the controversies. Central government overreach. Critics argue that governors appointed by the central government often act as agents of the ruling party, undermining the autonomy of state legislatures and hindering bills deemed politically inconvenient. Recent instances like the Maharashtra Farm Bills controversy and the Tamil Nadu NEET exemption bill has fueled these concerns. Erosion of state autonomy. Opponents argue that the expansive interpretation of Article 200 by the central government and courts undermines the federal spirit of the Constitution and restricts the legislative freedom of the states, impeding progressive legislation. Concerns exist that the governor's power under Article 200 can be used to stall progressive legislation on social issues like LGBTQ+ rights or minority rights, particularly in states governed by BJP. The ongoing debate surrounding Article 200 highlights the need for a nuanced approach that balances the governor's role as a constitutional safeguard with respect for state autonomy and democratic principles. Finding a middle ground through legislative reforms, clearer judicial guidelines, and increased transparency in decision making could be crucial in ensuring the fair and effective application of this significant article in the Indian Constitution. To conclude, Article 200 of the Indian Constitution embodies a delicate balance between upholding legislative autonomy and ensuring constitutional compliance. Understanding its intricate details is crucial for appreciating the dynamics of India's federal structure and the diverse forces at play in the legislative process.